this is the part where it doesn't work.
I wonder if it has to do with how many people are on it, but probably not.
Just the more people who are on it, the more it lags to increase my anxiety level. It's where the going live just goes in that circle and it doesn't actually go live, you know?
Do you have a number for the YouTube live too?
Now it even says it isn't streaming available right now. Hang on, we're going to try again. Oh, wait. And we're live. We've been live for 30 seconds, apparently. Who knew?
Great.
It is.
Fantastic.
It is June 29th, 2020, 5:01 p.m. YouTube hates me. I hate it. Repeal Section 230 right now so they can be liable for every bad thing that happens on YouTube. We are not allowed to have fun anymore. Marty Lederman is late, but the Supreme Court has handed down 3 major opinions today. We have an incredible group of people to talk about it. So we're going to dispense with the monologue and just get started. You viewers of In Lieu of Fun know Marty Lederman and Leah Littman. Leah Littman,
Leah. Get over this.
Leah and Marty.
You know, it is not, I have to say, it is not a Star Wars thing. It's a Hebrew thing.
Yeah.
No, we've been through that already.
Yeah.
Marty's like, there's no more excuses.
For those who don't, Marty is at Georgetown and former OLC and kind of a godfather of legal blogging and all that shit. Leah is at the University of Michigan. She's one of the gurus behind the Strict Scrutiny podcast, and she's super freaking funny. And Scott Anderson, who is new to In Lieu of Fun, right? Scott, you haven't been on In Lieu of Fun,
have not been on Lieu of Fun. I have been in the audience once or twice, but not in person.
Scott is my colleague at Lawfare and Brookings. He is kind of a badass. He's helped me with a bunch of the Baby Cannon videos. He's in a lesser,
the best Baby Cannon videos specifically.
A lesser daring do. Yeah, for those of you who have heard the oh so satisfying voice at the end of the best Baby Cannon video, that is Scott.
It is so satisfying.
In lesser accomplishments at the State Department legal advisor's office for a number of years, and was legal attaché in the embassy Iraq for a spell. He's a foreign relations law guy. So we're going to assign each of you a case. Scott, you're taking the foreign relations law case, the AID case. Leah, you're taking the Louisiana abortion case. Marty, you're taking that unitary executive case. Leah, let's start with you. It's the big news of the day. John Roberts, abortion.
The secret liberal. No, I'm just kidding.
He got on the court, became Chief Justice. It was all a charade just so that he could make NARAL happy. What do you think?
It seriously kind of looks like that lately.
Fact check, definitely false. While the Chief Justice did vote to invalidate Louisiana's admitting privileges requirement, which I'll explain in a second, his reasoning makes clear that he is no friend to abortion rights and in fact lays the groundwork for a legal standard that will be substantially less protective of abortion rights. So the Louisiana's admitting privileges requirement requires all doctors who provide abortions to get admitting privileges at a hospital within 30 miles of where they perform abortions. That is the same requirement that Texas previously enacted and that the Supreme Court had struck down in Whole Woman's Health versus Hellerstedt in 2016. Louisiana, however, looks around at the state of the world in 2018 and is like, hey, something's different. What is that thing? Justice Kennedy is no longer on the Supreme Court. And his replacement, Justice Kavanaugh, was nominated by President Trump, who promised to appoint justices who would overturn Roe versus Wade. So Louisiana continues to defend its admitting privileges requirement even after it's challenged. The U.S. Court of Appeals for the Fifth Circuit says, sure, the Texas admitting privileges requirement was invalid, but this law is a little bit different and might not impose as significant a burden. So the case goes up to the Supreme Court in a very fractured opinion, 4-1. The 5 justices vote to say the law is invalid, and 4 would have upheld it. It's 4-1 because Justice Breyer, joined with the other liberal justices, wrote an opinion that basically said, applying the reasoning that we wrote, i.e. Justice Breyer wrote in Whole Woman's Health versus Heller, said this law is clearly invalid. The Chief Justice concurred separately, saying that he dissented in Whole Woman's Health. He still thinks the decision is wrong. But respect for precedent and stare decisis compelled him to also strike down this law. It commands them to treat like cases alike. However, he then offered his understanding about the legal standard that governs abortion restrictions and says, so long as a state law has some reasonable relationship to a legitimate interest, courts need not inquire any further into whether the law offers any further benefits. That's different than what the court in Hellerstedt had suggested. There, the court said the state has to prove with evidence that a law actually advances a legitimate purpose. And then second, the Chief Justice said, the only question in the undue burden standard that determines whether a law is unconstitutional is the burdens it imposes. That is, courts do not weigh the benefits a law realizes against its burdens. Instead, it's just a burden-only analysis. And with that in mind, he concluded that the Louisiana admitting privileges requirement was unconstitutional. The 4 dissenters, the other 4 men, all wrote separately, and they only differed in how many precedents they would have overturned in order to reach this result. Some of them just would have overturned Hellerstedt. Others said, hey, let's refashion the law of standing while we're at it, and say abortion providers, or as Justice Thomas called them, abortionists, lack standing to challenge abortion regulation. So that was a long monologue, but that's it.
Yeah, that was great.
Let's make it a little longer.
Yes.
So the next case that comes up, normally the 5th vote is the controlling vote. So that would say that the standard that Roberts lays out, which is much more generous to states, would control. But here's what has me scratching my head today. If he strikes down the Louisiana law on the basis that stare decisis says it's an undue burden, whatever standard he lays out, if the next law that comes before the court provides about as much or a greater burden than Louisiana's law or Texas's law, is the controlling standard the 5th vote standard, i.e. the what Roberts lays out as his substantive standard, or is it's more or less burdensome than the law you've already struck down?
So 2 things there. One is, I think as a matter of formal legal doctrine, the controlling legal test would be the legal standard he lays out in his concurring opinion in June Medical, namely whether the law imposes a substantial obstacle on women seeking abortions. The problem is we don't actually know what, in his view, would count as a substantial obstacle to women seeking abortions. And
it's
the reason
less than an undue burden.
Right. The reason we don't know that is because he says, I still think I was right in Whole Woman's Health versus Hellerstedt. In that case, the Texas law would have closed the number of clinics in Texas so that instead of 40, there were 7 clinics, all of which would have been located in the major metropolitan areas in Texas. The district court found that would have left nearly 1 million women in Texas living 150 miles or more from the nearest abortion clinic. And so if in his view, that doesn't impose a substantial obstacle as a matter of the burdens on women seeking abortion, then it's hard to know what might. And of course, you can point to, well, in June Medical, he said this Louisiana law, which would have closed 2 of the 3 clinics in the state, constituted an undue burden. But if you read his conclusion in light of his reasoning, which is all about stare decisis and the outcome in Whole Woman's Health versus Hellerstedt, I think it's very likely that if a law came up to the Supreme Court and that law was not exactly like the kind that the court had previously held invalid, then he would have much more latitude to say, well, the burdens that this law imposes are less than the laws at issue in Hellerstedt or June Medical. And that's particularly true given that at oral argument, I don't know if anyone remembers, he asked only basically one question of each side. And his question to the challengers was basically, don't you concede that the burdens vary state by state, thereby building in considerable discretion to a standard that is focused on the burdens that a law imposes?
All right, so the bridge case here, Scott, is AID, which is both a reproductive rights case, but also a foreign relations law case. Walk us through it.
It is, in fact, maybe more of even a First Amendment case, an extraterritoriality case, really, than either of those things. But they all get kind of brought in to kind of interesting fact pattern. It's probably the least interesting by most standards of these 3 opinions, but still a kind of interesting one of how it lays out.
But it's a good nerd out case.
It's a real nerd out case if you're into it. And if you're into interesting dissents, it's a good interesting dissent case because a lot more going on in dissent than the actual opinion. It's a follow-on case from a 2013 case where the same parties, the Agency for International Development and the Alliance for Open Society, which is a group of NGOs, an American NGO that works overseas to do, among a variety of other issues, I'm sure, HIV and AIDS assistance and assistance and support services, things like that. In 2013, they challenged a provision of a law that provided a bunch of money that they were receiving for those services and for the assistance they're providing, but required them to adopt and maintain a stated policy saying that they are opposed to sex trafficking and sex work. And they said essentially, look, these policies, other than that, we don't agree with it. We don't think it's helpful for us to say these things. It's counterproductive for our mission. We need to be able to engage with sex working populations and other people in a way that's not hostile to them so that we can most effectively do our job. And we should not be compelled as American organizations to adopt and force a policy statement that we don't believe in that's not related to our work by the government. That's a First Amendment problem. This follow-on case makes a similar argument in regard to foreign affiliates of those groups, that after the 2013 opinion were still subject and made subject to the same restriction, basically saying they have to adopt this policy. The majority opinion by Justice Kavanaugh said essentially, yes, you do. And it's a very short, pithy summary opinion, no subsections, 5 or 6 pages tops, kind of gunning down a list of arguments where he basically relies on 2, what he describes as bedrock principles to resolve this matter. He says, first, over entities that are incorporated separately are considered separate legal persons, separate constitutional rights than their parents. And B, if you are a legal person who is overseas, operating overseas and not American, then you're not entitled to constitutional rights. And therefore found these foreign affiliates don't really have any entitlement to these constitutional rights. Simple, clean, over and done, and suggests that adopting any sort of other standard would involve the court in kind of difficult parsing involvement exercises that really the court doesn't want to be involved in and shouldn't be. Justice Thomas joined that view, but also went further and said, I would overrule the 2013 opinion. Nobody else co-signed to that particular view, but again, a kind of this 2-page little concurrence that came along with the 6-page majority opinion. And then you get to the other 2/3 or 3/4 of the printed opinion, which is a dissent by Justice Breyer, where essentially he says neither these bedrock principles that you're relying on, Justice Kavanaugh, are neither bedrock nor principles. In fact, you're severely overstating the state of the law on these 2 issues. First, that the court has traditionally avoided saying anything as categorical as saying that individuals operating overseas, for non-American individuals or entities operating overseas, have no entitlement to constitutional rights. He points to a number of cases that suggest there's a more nuanced and complicated standard there, including notably Boumediene, the case about the military commissions that Justice Kavanaugh cited for the opposite assertion in his opinion, basically saying, look, we have always tried to do more fine-hued analysis. We've avoided making such a categorical statement, let alone sort of asserting it openly relying on it to decide the merits of a case like this. And secondly, Justice Breyer points out that really we haven't drawn such a clear line between corporate entities in this space. He points to a number of other cases, including the distinction between 501c3 and 501c4 organizations, often which are more or less married into the same organization but operate under separate legal entities, as examples of cases where, you know, the law has accepted you may have separate legal entities, but nonetheless they share a lot of common features for the purposes of constitutional and other statutory analysis. In this case, Breyer basically says, look, looking at this case, we should have done a lot closer analysis, looked at these arguments that they're making to say, hey, these are closely affiliated foreign affiliates. They're operating often under the same name. Often they would be part of the same American organization, except they're required by local law of foreign countries to incorporate separately. That's the only reason they are. And under that sort of compulsion, we shouldn't allow that foreign compulsion to strip what is essentially an extension of American corporation of its First Amendment rights. He also, because of that, I think as a related sort of adjunct of that, says we should also take more seriously these arguments that there is a risk of confusion, that these views that are being forced upon these foreign affiliates will infringe upon the First Amendment rights of the American corporation, because people will think that's the American corporation, American organization, I should say, speaking. That's their speech, precisely because they are so closely affiliated, often sharing, I'm sure, the same name, same characteristics, things like that. And so in Justice Breyer's sort of passionate speech draws out a lot of these critiques of this very straightforward, brief majority opinion, but nonetheless, majority opinion carries the day and says essentially these foreign affiliates of this American NGO do not receive First Amendment rights because they are legally separate overseas entities, and therefore assistance to them can be conditioned on all sorts of requirements that would be unconstitutional if applied to a American corporation incorporated in the United States, or even a foreign corporation operating in the United States.
Wow. All right. Which brings us to decision number 3, the long-running CFPB decision, which is sort of about the CFPB, but is really about the structure of the executive branch. And Marty, walk us through it.
Yeah, I will, Ben. But you know what strikes me when Leah and Scott are giving these detailed descriptions of the first 2 cases, and the one I could give of the CFPB, and will, time permitting, is a real contrast between the 2 big cases last week and these 3 cases. The 2 big cases last week had enormous practical implications based on their very holdings, right? In Bostick/Harris, LGBTQ employees across the land now have the right not to be discriminated against in employment. And in DACA, of course, all of the hundreds of thousands of DACA persons here in the United States are protected, at least for the time being, until Trump tries to do something else. Whereas today, all 3 of these cases, I don't want to understate the importance of what happens to the CFPB or to women in Louisiana or to the affiliates in the aid case, but it's really the things the court says in the majority opinions in the 3 cases that are of far greater importance than the actual holdings and what they presage for future holdings by the court and by lower courts now filled with Trump judges who are likely to take all 3 of these cases and make more of them. So, I mean, just quickly, and I know we'll get back to it, in Scott's case, you know, by far the most significant part of that opinion is this flat statement that non-Americans overseas have no constitutional rights, full stop, categorical, none. What are the implications of that for other cases? How is that going to play out? I think as long as this is the majority of the court, that could have pretty profound implications, I think, but I think that will be up for grabs in future decades, depending on what the court looks like. What's really interesting about the abortion case, and I'm going to defer to Leah here. I asked her before the podcast, you know, it's being, I think, I haven't really checked all of the popular press on this, but the big headlines are, you know, Roberts goes 3rd time in 8 days in favor of a liberal result, you know, on social issues. And that's true with respect to women in Louisiana. It's obviously very important as to them. They will have access to abortions that they would not have had otherwise. But apart from that, the 2 things that he says Number one, that it doesn't really matter. We're no longer going to look at what the state's interest is virtually at all. Anything is legitimate. And number two, if I weren't bound by whole women's health, I'm not going to find a substantial obstacle, or I'm going to be hard pressed to find a substantial obstacle that any abortion regulation in the country asserts are really two major, they're not overruling Roe and Casey, but they're the next worst thing. Now, what I don't know, and what Leah will probably be able to speak better to, is what are the practical implications of those two holdings, unless and until there's either a change on the court or an overruling of Roe and Casey. And I don't know, Ben, if you want to discuss that question first, or we can do it after I've discussed.
No, I want an answer to my question first about CFPB,
okay.
and then we can come back and discuss the other.
Yeah, okay. But just I'll talk about.
This isn't the Marty Lederman show. This is the Ben and Kate show. No, I'm just kidding.
No, I want to hear from these guys about what the implications are. But anyway.
Yeah, but the whole idea.
No, it's
Marty,
a great question.
We wanted an outline.
We have to nerd out first. So
yes, we need to get all the facts.
Eat your vegetables first, Marty.
Okay, here's the vegetables. It's not going to be like, boiled Brussels sprouts either. I'll try to make it a little more appealing than that. So the Consumer Financial Protection Board, the Elizabeth Warren creation, Congress enacts it, and like many other financial and other administrative agencies, since the late 1900s, and even as Justice Kagan points out, even before that, tries to create some level of independence between this entity and the president, to take it out of politics, that there are certain functions within the executive branch Congress decides that ought not to be so responsive to the political whims of the day. Think, for instance, of Donald Trump wanting to regulate monetary policy to advance his own political interests, but not being able to because the Federal Reserve is thought to be independent from the White House. Or even, as Kagan points out, wanting to control the Postal Service, and he's not able to do that to the degree he wishes. The Federal Trade Commission, the NLRB, the Federal Communications Commission, the list goes on and on and on and on. And Congress creates many different mechanisms to preserve this independence. Part of it is simply statutory provisions that say the agency is independent, suggesting it does not have to abide by the president's wishes when it comes to policy discretion within the terms of the agency's statutory authorities. But one way that that's backstopped is by limiting the grounds on which the president can remove the agency officials, limiting it only to what is sometimes called for cause removal, or here, and basically an analog to that, for malfeasance, inefficiency, or neglect of duty. Which basically means that if the officer is not abiding by the law, or can't do her duty, or she's corrupted, or disabled, or she breaks the law, that's a ground for removal. But mere disagreement between the president and the officer about how to exercise her statutory authorities is not grounds for removal. It's a little more complicated than that, but that's the gist of it. And that's been basically upheld. That is the basis of the so-called independent agencies, many of which I just ticked off, for almost more than 100 years now, but especially since the New Deal, that we've come to depend upon. The so-called unitary executive theory, which is very, very dear to many on the right and otherwise, not only are those on the right, but some academics on the left as well. Their theory is, no, the Constitution gives the president the ultimate authority, not over the substance of what people do in the executive branch. Congress can say what their job is, but within what Congress says, all discretionary decisions are subject to the president's control. And that means the president has to be able to tell them how to exercise their authority and to fire them if he doesn't like the way they're doing it. That the executive power of the United States resides in the president, and he has to have control within the terms that Congress has set out. That they're in Chief Justice Roberts' words today, the words he used is, they're only wielding executive power on the president's behalf. Okay? They must remain accountable to the president whose authority they wield. Now that's really just inconsistent with how we grew up understanding the independent agencies. The way I've always taught it is they're not wielding the president's authority. They've been given statutory authority of their own, and the president can make sure they apply it within the terms of the law, but not beyond that. But there's 5 justices now who clearly believe the unitary executive theory in a very strong form. They believe that the Constitution says that the president has to have control not only over the officers who help him with his constitutional functions, like the Secretary of State, Secretary of Defense, but all the statutory officers who are administering statutes, like the CFPB and the like. Now, the court doesn't go all the way there. It at least nominally preserves the precedents under which these old administrative agencies, in particular the Federal Trade Commission and the Federal Reserve, being 2 of the most important, they continue to have their for-cause removal restrictions. They are, for the time being, they are independent. But, says the chief, the CFPB is different because instead of a multi-member agency, Congress here created a single director. And there are only a handful of historical examples of Congress creating single-headed independent entities, 3 or 4 of which are continue to be in existence today: the Office of Special Counsel, Fannie Mae, and the Social Security Administrator, in addition to the director of the CFPB. And the court says there's not enough of a historical pedigree for that kind of independence. When you put together independence and single-headedness, that's unconstitutional. It's too novel. It hasn't been tried enough in the past. I'm trying to invoke here a wonderful article that Leah wrote a few years ago. And this is a move that the current court makes repeatedly, which is if Congress tries to do something kind of new and improved, if it hasn't done something before, but it's using a newfangled way of dealing with a problem, sort of like the Affordable Care Act, it is constitutionally illegitimate, or at least disfavored. This is too new. It's not like the old independent agencies, and therefore it's unconstitutional.
Elena, if you're watching, I'd be happy to send you a copy of the article.
I'm sure she's read it. I'm sure she's an ad law geek.
It was just a joke.
No, it's great. Look, so I'll put my cards on the table. Justice Kagan's dissent tracks my amicus brief in many respects. It's not because she learned it in my amicus brief. She's obviously, she took the same class as I did. She read.
It's because we're right, Marty.
Great minds think alike. And it's the standard way that these things have been taught for many years, and this calls them into question. So what does it mean for the CFPB? Not a whole lot right now, because the court does not strike down all of Dodd-Frank. Justices Thomas and Gorsuch would have done so, but not the whole court. So it doesn't really mean much. It means that Donald Trump could fire the head of the CFPB for whatever reason he wants, if he wanted to. But he's not going to, because she's his appointee, and she had already said she would do what he says anyway. Ironically, in the short term, the person this will help will be Joe Biden if he's elected president. He'll be able to fire the Donald Trump head of the CFPB and put in someone who's much more consumer friendly, ironically enough. So the court just gets rid of this limit on the president's removal power, which has some implications for the CFPB. I don't want to make it sound like it's unimportant any more than the June medical is unimportant for women in Louisiana and the like. But the bigger concern is that the court's conception of the Constitution puts the president at the head of the executive branch and suggests that there's something very constitutionally dubious about the whole, what we call the independent agencies within the administrative state. I don't know that there are 5 votes for invalidating a lot of the ones that are very well established, especially the Federal Reserve. But I do think that they are sending out a signal that Congress must subject new offices to presidential control going forward. Whether that's the case will depend on who's on the court for the next 25 years, as with all 3 of these cases that we're discussing.
And Marty, just to clarify that, are you saying that that the current agencies, the FCC and the Federal Reserve, et cetera, are kind of grandfathered in, but new agencies, even if structured exactly the same way, would not be? Or that the structure itself is grandfathered in, and as long as you structure a new agency, very similarly to the Federal Reserve or the FCC or the, FTC, you're fine. It's only when you kind of create a novel structure that you're going to run into problems.
We don't know, right? So I just don't know that there are 5 votes. There might be 3 or 4 for actually declaring invalid the independence of many existing agencies, with even multi-headed agencies. And the chief's opinion itself describes what he's willing to accept. This is I think the most important and potentially groundbreaking or ground destroying sentence in the opinion. He says the exception to the rule that the president has to have absolute control is for multi-member expert agencies that do not wield substantial executive power. Like substantial obstacle in June Medical. We don't know what that means yet because, of course, dozens of the ones that exist now do wield substantial executive power. So he's sort of hinting that a lot of the existing agencies are constitutionally dubious, which will at the very least, I think, engender huge litigation in the lower courts for years to come. I don't know that there are 5 votes for. There's not going to. The Federal Reserve would be the last shoe to drop, right? At the end of all of this. I don't know how far they would go, but they are trying to set up a vision of the Constitution under which, at best, those things are grandfathered in, and at worst, there might be legal uncertainty as to many of the things they do for decades to come.
All right, Kate, do you have questions? We've now had an overview of the 3 cases. If you guys have questions for each other or disagreements, this is a great time for that. And meanwhile, all of you folks in the audience, this is a time to line up your questions in the Q&A, and we will rapture you in to pose them as we determine them worthy and relevant.
So I do have a question, and I think it's a good one to start on because it's a big picture question. And I think some of it we're going to get down into the weeds as we get questions from the audience. And also, I think it actually dovetails into Marty's question as well, which kind of, I guess, what I'm hearing from everyone, and particularly from June Medical, it sounds kind of like the general takeaway is like maybe John Roberts gave up the battle in this moment in sacrifice, like in order to win the long-term war and to kind of start laying tracks for kind of the war. And that maybe that seems to kind of be true in the limited nature of all of the holdings that everyone has mentioned so far. Is that being overly reductionist? I just feel like a lot of this is kind of like, we shouldn't be looking at, I think it's like it's just kind of a little dangerous to think of June Medical as a win for abortion rights, although it's not like a long-term, I don't know. It's not the bad. I think it's probably bad news for the long term, if that makes sense. And I don't know if that's me being pessimistic, because I'm always pessimistic about abortion cases in the court. But Leah, do you want to kind of kick us off? And maybe that's wrong. I don't know.
Yeah, no, I think that's.
Can I just add to it for a second? If I had told you yesterday, if I had given you this draft and said, you can have 5 votes on the basis of this concurrence in the judgment, and handed you the chief's opinion, would you have taken it?
If the choice between 5 votes with the Chief Justice's concurrence in this opinion or 5 votes going the other way, because 5 votes with the Chief Justice's concurrence is certainly better than 5 votes going the other way, because it at least allows the women in Louisiana continued access to abortion for the time being. 5 votes going the other way, would have sacrificed not only women in Louisiana, but also the future of abortion rights, which is what the Chief Justice's opinion does. So I guess that's a way of answering Kate's question, and that I think it's totally right to think that, the Chief Justice wasn't going to pick this particular fight, given that the court had already struck down this law. But he really did pave the way for future restrictions on abortion. And in some ways, this is exactly what happened with Planned Parenthood versus Casey. When the Supreme Court was asked to overrule Roe and Planned Parenthood versus Casey, 5 justices said no. But of those 5 justices, you had a group adopting a more narrow reasoning that said, we're not going to overrule Roe in its entirety. Instead, we're just going to adopt a different legal standard for adjudicating abortion restrictions that is substantially more lenient toward the states and permissive in allowing them to restrict abortion. And that's essentially what the Chief Justice did today, saying, well, I'm not going to overrule the result in Hellerstedt to the extent it commands me to reach this result here, but I am going to substantially trim back some of its legal reasoning to the extent it would have called into question other abortion restrictions. And I can stop, but I was going to, well, we can come back.
Let me push back on that, because my reaction to this was that the substantive change in the law, at least as I understand it, is to replace as the operational test the words undue burden with I don't know, but like practical obstacle. I forget what his language was, but it was and both of these are essentially meaningless phrases except what 5 justices think they mean. And so why shouldn't I look at it as supplanting one empty phrase that means whatever 5 justices think it means with some other empty phrase that means whatever 5 justices think it means. And therefore, the principal effect of this is to buy time. And the relevant question is not what the functional standard is under the law, but who's on the court the next time a major case comes forward.
So it's possible that if the next time the Supreme Court hears this, or an abortion case, the composition of the court is different, that it would be possible for a court committed to abortion rights to aggressively enforce this standard by saying, well, any obstacle, whatsoever, any burden is substantial. The reason why I think that this legal standard in particular, however, is not protective of abortion rights is twofold. First is it jettisons an independent basis, a potentially independent basis to invalidate a state law. Whereas the prior legal standard said if the purpose or effect was to impose a substantial obstacle, then the law imposed an undue burden. And the way that the court had suggested a law had the purpose of imposing a substantial obstacle is if the law didn't demonstrably provide some material benefit to women's health or safety. So let's take, for example, laws that ban common methods of second trimester abortions like D&E, or laws that move back the point at which abortion is legal from 23 weeks to 20 weeks, or non-discrimination provisions that say you can't obtain an abortion on the basis of race, sex, or disability. States don't yet have scientific evidence that they can walk into court and say, look, I can show you that these actually improve women's health or safety. And so if that were still the legal standard, then those laws would potentially fall. Now, however, the litigants challenging them would have to come up with evidence along the lines of, here's the substantial effect that this law imposes, and that's why it is invalid. And part of the reason why we know this standard is more permissive is because it's a standard that the Court of Appeals had used in the Fifth Circuit case to uphold the Texas admitting privileges requirement. And it's also the standard that proponents of more restrictive abortion laws are arguing for. And so I think for those reasons, we kind of know what this standard looks like in operation, particularly in the hands of this court. And as Marty was suggesting earlier, the lower federal courts as reconstituted by President Trump.
Ben, can I suggest, I think you're both right. And I'm just, trying to be nice here, right? So I think Leah's right that that by both basically saying to the state, you don't need to even develop a record that there's some valuable reason for this. Your objective could simply be to stymie women from getting abortions, full stop. And signaling that the chief himself thinks that the obstacles in the Texas and Louisiana cases were not substantial. It's inviting legislatures and lower courts to strike down things that would not have been struck down before. So Leah's right in that respect. I think it will have that impact. But you're right as well that it's a holding pattern in the sense that it is I suppose, less dramatic than if the chief had actually overruled whole women's health, just with the symbol, or further than that, basically said Roe and Casey are either gone or just not worth very much anymore. It obviously will have less of an impact on the election than if he had done those more dramatic things. And you're also right, of course, that the fate of actual practical access to reproductive freedom in America will in fact depend, however the campaigns treat it, is going to depend hugely on the next several Supreme Court nominees.
All right. Jakob Hecher, the floor is yours. Please unmute yourself.
All right, can you hear me?
Indeed.
Yeah.
Wonderful. So looking at the Louisiana case and your discussion so far, I think it's fair to summarize it as like a salty runback, right? Of effectively the same law that was already struck down, just with a few words tweaked around, right? So what consequences or what measures, if any, are there from just the same thing happening 2 years from now, right? Like another state passing effectively the same law with a few words twisted around, some superficial differences that are just enough to provide some appeals court judges a fig leaf to punt it to the Supreme Court again. And then we have another Supreme Court litigation again litigating reproductive freedom, right? Is there any barrier to just women having to worry about access to abortion again every 2 years? And if there isn't that just completely fucked? Like,
Jakob, are you asking about physician requirements in particular, like in these two cases, or more broadly, abortion?
Like just in general, like what's stopping another state from passing the same law that was struck down?
The answer is like nothing is stopping them. Like in the wake of Whole Women's Health versus Hellerstedt, literally a day or two after that decision, Texas came back and said, here's a new host of abortion restrictions, right? Here's a fetal burial requirement. Here's, all of these other restrictions. And this is, within 72 hours of the Supreme Court telling them, no, you actually need to be able to walk into a court with demonstrable evidence that this law, advances some legitimate purpose. So long as politicians remain committed to restricting women's access to abortion, so long as there is at least an open question about whether courts will allow states to get away with this, then there really isn't much stopping states from doing this. This is partially why some politicians have argued that there should be federal statutes protecting, women's access to abortion, or other precautions as well. But as it stands, yes, I would agree with you that it is rather fucked.
Kyle, the floor is yours. You got to unmute yourself.
Hi, can you hear me?
Yes.
Hi, my question relates to the CFPB case. I was interested in the severable issue in that case and how the court's precedent may apply to the upcoming ACA case about whether portions of the ACA, if unconstitutional, would be able to be severed from that statute.
So great question. Marty, can you give us the before you answer it, the 90-second explanation of severability so that the 85% of the audience who does not know what severability means will not be completely lost as you answer the question? It's a great question.
Okay, severability, let's put it this way. Statutes have thousands of provisions in them. Congress enacts a law, it's got a lot of different provisions. One provision might be constitutionally suspect and become the subject of constitutional dispute. Let's say the court holds, yes, indeed, that provision is unconstitutional. The question in severability is, what does that mean for all the other dozens, hundreds, thousands of provisions in that same law that are themselves, standing alone, perfectly constitutional? Are they still operative? Or does the whole thing fall because one part of it falls? Something the court is usually very reluctant to say. The presumption, very strong presumption, is that Congress would prefer to keep 99% of its handiwork, even if 1% of it gets struck down. But there is this theory that certain provisions are so central to a statute that if you take it away, the whole thing should fall apart. Congress would never have wanted to do that just based on it would never have wanted the statute to be upheld at all, given that this one critical component was no longer operational. So that is in the coming Affordable Care Act case that will be argued next term. The argument is that the 2017 GOP-led Congress inserted an unconstitutional provision into Obamacare, which is itself absurd. Okay, but once that question is done, if you agreed with that, their argument further is that, oh, and by the way, because there's this one completely irrelevant unconstitutional provision in it, the whole healthcare system of America has to be declared invalid. And that's the severability question that is at issue in the ACA case. There is language in today's CFPB case that I think ought to be very helpful to the sustaining Obamacare on the severability point. Not that it should have been a close question even before today. The Chief writes, we think it's clear Congress would prefer we use a scalpel rather than a bulldozer in curing constitutional defects, right? Especially where Congress was aware that the one provision might be unconstitutional. So I think it sends, the ACA case, in my own personal opinion, it depends on two arguments by the Solicitor General that are the two most preposterous, legally worthless arguments I've ever seen the federal government make. The first is that the Republican Congress in 2017 created an individual mandate to maintain health insurance, which is the opposite of what they were trying to do. And the second was that once they did that, they also intended to take down all of Obamacare. I think today's decision ought to, I hope, indicate that if the court even reaches that second question, it should unceremoniously say, come on, you've got to be kidding.
All right.
Can I add one thing to that, Ben?
Yeah, please, Scott.
Well, I was just going to say, just in thinking about the severability question, particularly in a case like CFPB, like the CFPB case, where it's a more structural approach and may have implications for institutions kind of across the federal government, all sorts of different arrangements Congress has put in place. I think it's dangerous to think of it too categorically about one way or the other in terms of a desirable outcome. And a case, I think an interesting parallel, I guess, just as a thought exercise, is what happened after Chadha, or what could have happened after Chadha, I guess, right? Where we see these limitations and these structures about how we set up leadership being integral to the way that Congress has given substantial authority to independent agencies, but to some extent the executive branch, right? And often we're like, oh, it's a CFPB. Of course, we want to see Congress continue to see these tasks done. And the fact they changed this leadership, it's better that they sever that out and we let the rest of the agency continue the job, even when we lost on this one issue, right? But, down the road, 20 or 30 years from now, I don't think it's unrealistic to think of a case where we have to ask ourselves, did Congress really mean to give this much authority to the president without having that control of the extra autonomy or independence? So if this, this precedent ultimately does lead back to a challenge of the Federal Reserve Board, a million reasons why it probably won't. But if it could, wouldn't we want a question to say, did Congress really mean to give this much authority to the president without the check of the independence of the Federal Reserve as it was originally designed? But the severability would basically let the president resume that authority, because it would let the court say, we're going to strike this restriction on removal. And all of a sudden the president has all this authority, not this independent body. Same thing kind of happened with Chadha. Chadha was all Congress actually amending these statutes after the fact most of the time, which is kind of ill-advised. Seems less likely to happen here, although it's worth thinking about, I guess. But, you think of the National Emergency Act, the War Powers Resolution, all these things function so differently when Congress enacted them. And when you saw Chadha come out, in that case, Congress itself, but in theory, future legal challenges because it severed out the legislative veto provision and led to what we have now, which is a huge, much broader delegation of authority to the executive branch than actually existed in the original statute. So I just mentioned that because I think I think the severability, as we think of it in these two contexts, it's something that is a bit of a two-edged sword.
It's a very interesting point. Kevin R., you have the next question.
So in this term, we've seen two cases now that basically involve the rights of foreign persons, and the AID case today and Hernandez a few months ago, the cross-border shooting case. And I'm wondering whether, if we look at those and back to the Guantanamo cases, is a court coming to some consistency as to what the rights of foreign persons or persons on foreign soil look like? Or is there still kind of a lot of gray area here?
These five
Scott.
justices. Oh, go ahead, Scott.
I'm sorry. Marty and Scott,
No.
this is
Go ahead, Marty, please.
Heartland, you guys.
These five justices would say the president has to have complete control over the executive branch, CFPB. The president has to have unbounded control over how to treat foreign persons overseas. I don't think there's any doubt that if they were starting from scratch, these five justices would say both of those things. Oh, and by the way, the Constitution doesn't protect abortion rights at all. So we have five justices who, given their druthers, would be categorical on those things. But I think, and to the extent they continue to control the court for decades to come, they or people or justices like them, those will increase, the law will increasingly get very close to those three categorical rulings. But with a change on the court, no, I think of the different, in each of these three cases, you can think of cases where the other justices would say otherwise. Does it really mean it's constitutional to torture prisoners overseas? Does it really mean that the Establishment Clause allows for discrimination among religions overseas? Does it, Justice Breyer gives other examples of that. Does it really mean they'll strike down the Federal Reserve as unconstitutional? Maybe if these precedents stick and the justices stick, but that just goes to show why Mitch McConnell is by far the most important and influential legal actor of our lifetime, right? I mean, the one move that McConnell made had just in the 3 years since he's done it, has had just an enormously profound effect on the law and will continue to resonate for decades to come.
Scott, what do you think? Are we approaching something like a consistency to questions of extraterritorial application of constitutional rights, or are we functionally nowhere near it?
I think what Marty said makes sense to me. I think I agree with it, which is to say, it certainly looks like these five justices believe they have reached an internal consensus about what it is. And look, I think you can get that from the structure of the opinion, if nothing else. Kavanaugh is a guy who writes long opinions. Anybody who's ever dealt with the DC circuit and dealt with his opinions knows you've dealt with, 100+ page opinions on the regs. And yet here, he only really thinks these issues are worth 6 pages, 7 pages, 8 pages. I don't want to read too much into that sort of thing, but it seems like there's a pretty clear consensus. They don't think it's reached here. Now, part of that is because they are segregating out the complicating questions, right? They say, oh, but of course, an accepted, caveat of this is when foreign individuals are operating on U.S. soil. In fact, they're able to access some constitutional rights, and they lump Boumediene in with that exception, right? But that's actually a kind of complicating way to read it. Then the question of, well, what is, the equivalent of U.S. territory or soil? If we're going to talk Guantanamo Bay, the equivalent of our territory or soil, when do the rights adhere? There's a long tradition in sanctions cases in the DC circuit and other circuits of saying entirely foreign entities, when they appear on U.S. soil, if they have $1 in a U.S. bank account or, a nickel to their name in the United States, can assert a due process challenge to their sanctions challenges. Why is that operating on U.S. soil enough? So it shifts the complications to a different zone. But certainly the five justices in that opinion have a lot of confidence in what they're saying. They don't think it warrants even much more elaboration in the face of a, pretty strong dissent by 3 of the justices, the more liberal wing of the justice, if you will. So of the court. So I do think there's some consensus there, but Marty's point is well taken. 5 justices is not an enduring consensus necessarily. And so perhaps some of that confidence is a little misplaced.
I'm kind of curious. I want to go back to Leah. Leah, how weird was it? How predictable was it that there were so many separate writings by all of the male justices? I really actually loved how you threw up the front pages of all of the different justices and their takes on June Medical. It was, you could easily make a meme out of that, I feel like. But what did you take away from that? Is there something to take away from that except the fact that I'm very curious why they would be so eager to turn over, or how they could justify turning over established stare decisis, like established precedent in a lot of these cases, and it just kind of seemed, they all just seemed really strange to me.
Leah, you should explain to the viewers how weird this is, right? There's 6 men and 3 women on the court. There were 6 opinions. How many women wrote, Leah?
Yeah, exactly. That's kind of what I mean by like the meme. It's like
in a case about women's reproductive freedom, 6 guys write and 0 women write.
Yeah.
Right. I thought that was like, I mean, that was almost, it was almost darkly too good to be true. Like it just was like, it was like a comedy, like a dark black comedy.
It's extremely telling, insert all the Handmaid's Tales under his eye memes. No, but like, why were there those separate writings? I think sometimes in, big cases, these, ideologically salient, divisive cases, you will get multiple dissents. This happened in Obergefell. This happened in Whole Woman's Health, so that's not that uncommon. But I do think that the different dissenting opinions here between the, 4 conservative men, all of whom were just falling all over themselves to find different ways to restrict women's reproductive rights, revealed some divisions among them. On the one hand, you mentioned how could they just like sweep aside all of these precedents. You have people like Justice Thomas and Justice Gorsuch who are like, stare decisis, what's that, right? Like, I don't agree with it, right? It doesn't require me to adhere to any case I think is, egregiously wrong or demonstrably erroneous, as Justice Thomas has formulated. So both of those justices have already written separately to indicate that they have more narrow views about stare decisis than the others. And then the other, side is
in the context of abortion, or in
abortion and otherwise.
Thomas does not believe in stare decisis in constitutional
he thinks it's inconsistent with the judicial role.
Right. I know him, but the rest of them I didn't know were going to be tripping over themselves.
So Gorsuch had already written separately in the double jeopardy case from last term, indicating that he also had an extremely narrow view of stare decisis, and outlining, all of the reasons why he thinks courts should be willing to overrule decisions that they think are wrong. And then the other, side of the, 4 are, for lack of a better word, the gaslighters, right? Like, oh, watch me, like I'm adhering to precedent. I'm not overruling, Casey and like Hellerstedt, but like watch me come up with like all of these, specious distinctions and like give Susan Collins a pass for voting to confirm me. And, that's in some ways like what I think was going on there.
But with all, I agree the optics of it are terrible, but I do think it actually reflects something substantive, which is that the 4 more liberal justices actually all agree about this subject, and the 5 conservative justices don't. And they don't agree. Well, they may, as Marty says, they agree as an original matter that the entire line of cases is wrong, but they actually disagree in a pretty substantial way about what to do about it. And I think some of the 5 opinions that you saw today is a reflection of the fact that they actually have a the fact that Breyer wrote the opinion for the 4 is, I assume, a reflection of Ginsburg having assigned it to him because, or the chief having assigned it to him because he wrote Whole Women's Health. So I'd leave that nail out of the, but the other 4, the other 5 actually have somewhat different views from each other.
Yeah,
and it
makes total sense for the chief to write separately. He voted differently. But I do agree that the Justice Gorsuch and Thomas on the one hand do differ from Justice Kavanaugh and Justice Alito on the other about how to get to the bottom line conclusion, which is, the Constitution allows states to freely regulate abortion.
It just seems like it just, as Marty says, just like the pure optics of it. I just can't believe someone didn't get out, like one of their clerks wasn't like we're, maybe we shouldn't all the men shouldn't write 5 separate concurrences. Like, this is going to be a bad look. I don't know. It just hit me as kind of.
That depends, Kate, I guess, on who they think their audiences are.
Yeah, it's true. I guess that's right.
The audiences that they're writing for, I'm not sure they really care that 6 men wrote. And
I think that's right. And unfortunate.
So I tweeted something early in the morning that was meant as a provocation, and it was received that way. And I'm curious what you guys think of it, which is I tweeted that, to a certain extent here, Roberts comes out, at least technically, the right way on Bostick, on DACA, and on June Medical. the social cases. And those are the headlines, right? John Roberts, apostate. He's going the right way on all the social issues. And I don't think he minds that, although I don't think that's the sole or even the principal reason he's doing it. But sort of like he is now the Anthony Kennedy that the right can't abide. But in the meantime, the things that he thinks and that they think are much more significant, structural, voting, race, structure of the executive branch, executive power. We have the subpoena cases coming next week, 3 religion cases starting tomorrow, I think. Religion, religious freedom, and the like. He's all in. And he's sort of willing to give on these things, in part because he doesn't care as much about them, in order to do those. So my provocation was, I said, I'll bet the Federalist Society would gladly trade Bostic, DACA, and June Medical for Selah, which is the CFPB case. And I got some pushback from some FedSoc types saying, you guys don't know what we care most about at the Federalist Society. We're not happy about those 3 decisions. And of course that's right. The Federalist Society is a very, very broad tent. It's a broad tent within conservative circles. There are many different things going on within the conservative judicial movement, some of which are social, some of which are jurisprudential, some of which are executive power-based, religion-based. There's a lot of different components, and I'm sure there are different views. But I think the Selah decision is the one, first of all, because I think June Medical, as we've discussed, is on the whole bad for women, not good. But I think Selah is the one that's the most concerning of the 5 that have been decided in the last 2 weeks so far, or the most important as a practical matter, but maybe time will tell.
John Bordeaux, you get the final question because I saved you for last because you have the forward-looking question, which Marty just teased. So
sorry, John, I didn't see your question. Sorry.
No. John's going to flesh out the statement you just made. John, the floor is yours.
Thank you. No, it's all good, Marty. As regards coming attractions, these are 5 decisions in the last 2 weeks, and I think the august panel here has been thinking about where the justices are going. What hints or new tea leaves do you have that tell you what might be coming in the next few weeks?
Who wants to take that one?
So let me tee it up and see what you guys think. So there are basically, there are going to be 8 more opinions, right? Or yes, 8 more opinions. 3 on religion, 2 on subpoenas, electors, which might be 2 opinions, but it's really 1, and then a couple of other cases that are actually very interesting, but much less important, like whether most of the state of Oklahoma is an Indian reservation. But so the 3 religion cases, I will be very.
That's a fascinating case.
It's a great.
I think that's an amazing case.
Like a fascinating.
But Ben, if you don't think we've nerded out enough here, we can get into McGirt if you want.
No.
Yeah, that's a separate thing.
The day that case comes down.
Oh yeah, you're going to devote 3 hours to that one. Okay.
No. Like you have no idea how much time I've spent with that case. I listened to all the arguments. I read the briefs. I've really nerded out on that case.
Okay.
What?
The question
and
is,
by the way, the state
Kate
of Oklahoma should be mostly returned to the tribes.
What's that?
The state of Oklahoma should be mostly returned to the tribes. The circuit opinion is not wrong about this.
All right.
I just generally think that tribal law and like First Nations law is fascinating when you start getting to like sovereign, like we just don't even, like if you've ever spent any time at a reservation, just like the tribal police versus regular. I mean, I just think it's a fascinating jurisdictional issue. So go ahead.
I dare you guys to announce in advance we're going to do an In Lieu of Fun about the McGirt case and see how many people show.
Consider it announced. We're when that case comes down, we're gonna. I hope it doesn't come down tomorrow.
I think Leah just mimed throwing down a gauntlet. I think that's what she.
We're totally doing it.
I'm there for it. Okay.
All right.
So
anyway, you were saying, Marty.
Very likely, all 3 of them will come out on the side of the religious objectors or the religious adherents. Maybe not. I mean, it could be that the Montana case, because of its strange posture, doesn't reach the merits. I think the chief is writing that one, and I think that both the contraception case and the ministerial exception case will come out in favor. And how they're written on all 3 of those cases makes a huge difference. There can be very broad rulings or very narrow rulings, but I'd be very surprised if they're not all religion. The two subpoena cases, just based on oral argument, I think it's pretty clear that they're going to uphold the grand jury subpoena from New York, which is the far less important case because the grand jury has secrecy and Trump's records will not get out of the grand jury. On the congressional subpoena, which I think is the most important, I fear that there are 5 votes for saying that it's unconstitutional, although I think that's very wrong. I wouldn't be surprised if the court goes the other way. And on electors, I think most everyone thinks it's 8-1 or 9-0 to uphold what Colorado and or Washington did on that. So that's my tea leaves, but I'm notoriously bad at predictions. So
what do you guys do? Do any of you have predictions, particularly predictions informed by what has already happened?
I think it's difficult to make any inferences based on what happened, in part because almost all of the remaining cases are from the May sitting. And so you can't divine, which justices might be writing which opinions, aside from the Montana religious discrimination that Marty noted the chief is writing. So unlike with the February sitting, where I think it was pretty clear that the chief justice was going to be writing Selah and Justice Breyer was assigned June Medical, the abortion case, it's difficult to know particular authors, which might, point toward particular results. But as to the outcomes of the cases, I think I agree with Marty just based on the oral arguments in the cases and the justices, prior writings and whatnot.
I would like to say that whatever I do think the right answer in McGirt is for the tribes to win. I will predict that they do not win. The case got held.
Oh, really? I think the tribes are going to win that one.
I do not think they're going to win.
So just for our viewers' edification on this most interesting of all Supreme Court cases, the same issue was argued last term or the term before, and it was 4-4, and because there was a recusal, right? So Gorsuch is the only vote that's really in play, and Leah and Ben are sort of disagreeing about what tea leaves he was reading from at oral argument.
You've already committed to have another episode. Don't give away the goods.
No.
You gotta drag people back in.
It is a fabulous case, and the history of it is unbelievable. And it may come down tomorrow for all we know. Leah, Marty, Scott, thanks for joining us.
This was so great.
And we may ask you guys back tomorrow, depending on what comes down. We're not going to schedule anything else until we see what's coming down, because, we may have to nerd out again tomorrow. Until then...
Wait, Ben, can I make a suggestion? It would be, just because I'm curious about all these stories and accounts of, the FedSoc or the Conservative Judicial Project, what they take of this mixture, particularly after these next 8 cases are decided. If we could get someone on just as a reporter, like what is
why not have a bunch of FedSoc people on?
What?
They're my buds.
I know they are. That's why I'm asking you. I would just be curious, like what is the scuttlebutt? Are people upset? Are people happy? A mixture? Is there this real rift within the conservative movement that you
tell me what kind of FedSoc people you want? I'll get them on.
What kind of FedSoc people?
Well, there's as you say, there's 100. It's like ice cream, 31 flavors. It's so many different.
It's really not that many flavors. It's like a very narrow, not broad, narrow, but deep list of people who all look the same.
Crowd, you got your libertarian crowd. You got your. There are many flavors of.
It's like the distinctions between the
vanilla, French vanilla.
Yeah, it's like the many. There's at least 8 different flavors of vanilla.
Really people,
vanilla with sprinkles.
Ben,
French vanilla.
Ben, this is what they pay you guys the big bucks for. You got to decide.
I am totally down with having the all FedSoc.
We're gonna have to discuss this.
Until then, Kate.
Let's not fight in front of the children, Ben.
I do, by the way, Leah, love the picture of Roberts in back of you. I think it's he's appropriately menacing looking.
Exactly. He's very unhappy with Louisiana, the Fifth Circuit, and his dissenting colleagues.
Yeah, he's the weight of the world is on his shoulders.
Not nearly as unhappy as Alito, who just gets angrier by the week.
The first interview Roberts gave after he was confirmed was to me, as part of this book that I was writing about the judicial confirmation process. And so he hadn't even fully unpacked in the Chief Justice's chambers. And he ushers me in and he shows me this bench and sits me down on this bench. And then informs me that this is the bench on which John Quincy Adams had died. And it turns out that this bench had been in the halls of the House of Representatives for like 100 years. And when Adams collapsed with a cerebral hemorrhage or whatever on the floor of the House, because he had run for House after leaving the presidency, he was dragged out and put on this bench and expires on the bench. And somehow the bench ends up in the Chief Justice's chambers. And I was sitting there for the whole interview, kind of like looking at the bench. I'd never like done an interview on a bench on which a president had died before. And so it was a really weird experience. And I've always wondered whether Roberts was trying to put me a little on edge, or whether it was just a sort of jocular thing.
The man is not stupid. I feel like
he's a very bright
yes.
Like, sign off and I don't want to make fun because it has to be we don't have fun anymore. But
we don't have fun anymore.
Justice Kagan's opinion, which I think is a masterpiece in dissent, it was the first Supreme Court opinion ever to use the phrase spoiler alert.
You know, Justice Kagan is like actually creating a new form, which is Supreme Court sort of
colloquial,
like interstitial humor, like these sort of passing remarks, the Spider-Man references, the spoiler alert stuff, and they're never central. They're always, Scalia would do these sort of big bang rhetorical things, but she just kind of like laces them in like it's like a scalpel, not a bulldozer.
And they're also evocative of the point they actually make her point very well.
No, they're beautifully done.
Like the reference to Schoolhouse Rock today, or the use of the word piker, or as Leah and I enjoyed because it's relevant to Leah's article, she says the necessary and proper clause is not the rinse and repeat clause as the chief tries to make it. And that image really kind of it works. It doesn't just seem clever in the way that I think a lot of Scalia-isms often were. Like she's trying to use colloquial terms to try to illustrate a point very effectively.
I think Scalia's references were also like to classical references. They were like inside jokes for really smart people. I don't know. This is just she's much more pop culture-y.
Yeah, she's more, but at his best, I mean, this wolf comes as a wolf is a brilliant distillation of the point he was trying to make in Morrison. But it's not something that Kagan would ever have written.
Speaking of which, today the majority opinion is the hunter in Peter and the Wolf coming to kill the wolf.
Yes. There you go.
Roberts' opinion. So,
all right. Thank you all. Kate, until tomorrow, 22 hours and 47 minutes from now. What do we say?
We don't have fun anymore. So in lieu of fun, go listen to Peter and the Wolf. I don't know. I'm really tired today.
Read
the that's all I got.
Read the briefs in McGirt and be prepared to discuss.
Yeah, read the briefs in McGirt and be prepared to be cold called everyone who attends. Yeah, like Leah likes that idea.
See you tomorrow.